communication?
We'll start in just a minute. I have 6:59. We'll call the meeting to order. This is the Zoning Board of Appeals for Tuesday, August 30th, 7 o'clock. Before I go to the roll call, I'll just indicate to members and to the public, for whatever it's worth to the public who's in attendance, we don't often sit as the Zoning Board of Appeals. We are normally sitting as the Zoning Board of Review. In this matter, we are listening to an appeal that's been made of a planning board decision. For members, you have to have your mind set in the proper direction. You were given the criteria by the appellant's attorney, the town's council, and even from the zoning official as to how we are to approach an appeal. If there are any questions in that regard, just be candid about asking them, but it was pretty direct and clear as to what our legal authority is and what our process should be. So with that said, I'll ask for a roll call. Here.
Mr. Martin?
Here.
Mr. Pasquarello?
Here.
Mr. Marcantonio?
Here.
Mrs. Burlington?
Here.
Mr. Marston?
Here.
For the record, Mr. Marston will serve as, in place of Mr. DeZiel, so as the alternate, you will be a voting member. Okay, item 3, disclosure of no compensation or pension credits received by board members. All the members sitting in front of you are appointed by the town council with no compensation. Item 4, disclosure and notice. The Zoning Board of Appeal members shall disclose any ex parte communications about any contested or material adjudicatory facts or opinions concerning merits of any application before the Zoning Board of Appeal. Item 5 is the primary agenda for tonight. It's the appeal. Islander Solar LLC, Joseph and Sandra Authier, appealed the decision of the Town of North Smithfield Planning Board regarding their denial of the master plan for the property located at 0 and 850 Iron Mine Road, Plat 16, Lot 18 and 19, zoning district is RA. Before I invite, and I would assume we would defer to the appellant to make a presentation first, and then the town, as town wishes. Before we do that, I want to enter into evidence similar to what we do with our other normal zoning board of review meetings. We'll enter into evidence the material that was received.
Robert, you want to make sure that Steve can hear us?
I'm sure he can. He's listening on Zoom. Yeah. So from the appellant, we'll call it A, use that designation, A. A1 is the cover letter dated July 19th from Darrow Everett LLP, attorneys and business advisors. It's to the Zoning Board of Appeals regarding this matter. It's a single page. A2, we will call the attachment, a statement of support for appeal. It's from Island Solar LLC. It's 1, 2, 3, 4 pages. And again, everything I'm reading, all members should have received in their packet. A3 was the notice of appeal. It's the Town of North Smithfield's notice of appeal, which was filled out by the appellant. And it's signed. It's dated 7/15/22, and it's the document that our town gives. A4. I have it as the Town of North Smithfield Planning Board decision letter dated June 7th of 2022. That document is 3 pages long. A5 will be the submitted by ESS Group, dated January 7th of 2022. This is the Environmental Consulting and Engineering Services.
9 pages.
It's 9 pages, thank you. 9 pages, and it is addressed to a Mr. Charlie Roberts, Islander Solar LLC.
You referenced the date, right?
I did, yeah, I gave you the date as January 7th. So that is, for the appellant, that's what we have as submittals, is that?
May I approach? Because I do have things to add.
Why don't I let me introduce the town's information, and then we can do that, okay?
Yes.
So from the town, which all of you should have received yesterday or this morning.
This
Okay,
morning.
this morning. We have, we'll call it T1. T1 is the cover letter from Attorney at Law Igliozzi and Rise, dated August 29th of 2022. Yep, and that's a two-page document. Also included was a similar, we'll call it T2. It's the same information, the June 7th letter from the Town of North Smithfield Planning Board decision letter that we already entered. T3 will be the meeting minutes, Town of North Smithfield Planning Board from their meeting on April 14th of 2022. And that's,
Also, the exhibit, or,
well, that's part of the attachment, so it should be part and parcel, so.
so what planning board meeting was that? What's the date again?
That was the T3. So I printed these on two sides, so hold on.
No, what was the,
What's that?
the name of it?
Oh, these are the minutes,
What date?
meeting minutes from April 14th, 2022. Okay, so that's that. T4 would be the meeting minutes from the Town of North Smithfield Planning Board. Date is Thursday, May 12th of 2022. And then T5 is also Town of North Smithfield Planning Board minutes from the date of May 26th, 2022.
If I remember correctly, that's in Mr. Igliozzi's packet, right? All those minutes?
Yeah, that's all from the
But you didn't
town. What
bust it out of that, you had those separate?
do you mean?
Well, all those,
Yeah, those are all part of this packet that we received.
so you split the packet up? Is
Yeah,
that what you did?
yeah.
Okay.
And then you also received, as part of what was presented, was, we'll call it T6, I believe, is the same information that's Title 45, Towns and Cities, Chapter 23, Subdivision of Land. It's just a recap of the laws that apply to this type of an appeal. Okay? So if we've included everything, we'll defer back to the appellant if you need to add some information to the submittal. Yes, please. I don't think, you don't need to swear yourself in, of course, but do we have a, we don't have a stenographer, right? So we're just going on the record. Okay, okay. You can introduce yourself for the benefit of the members.
Good evening, Mr. Chairman, members of the Zoning Board of Appeals. My name is Kelly Morris Salvatore. I'm an attorney with offices located in Providence, and I am here representing Islander Solar regarding property owned by Joseph and Sandra Authier. This is an appeal of the decision of the North Smithfield Planning Board, which denied Islander Solar's master plan application. Just a couple of procedural matters, Mr. Chairman, because I don't think my package was in the same order as yours. I want to be sure that you have my attachment to the notice of appeal, which consists of 4 pages. It's kind of my detailed summary of our arguments. Thank you.
Yes, we do.
Okay.
Yes, it's 3, oh no, it is part of A1. Or it is
Yeah,
A2?
I just wanted to
Yeah.
be sure, yes.
Yeah, it's where you note what, you reference, pulled from the minutes, the comments made by members, yes.
Okay.
That was attached to your cover letter.
Yes, okay, thank you. And then, Mr. Chairman, also, I had talked to you before the meeting about the planning board's, the submission to the planning board from Edward Pimentel. That, I did not hear you, I did not submit it, and it is, you do not have it in your record.
I thought you were, my mistake, I thought you were referencing the ESS group report.
No, this is
That's not it.
separate.
Okay.
So just for reference, typically, the planning board should be sending to you all the documents related and submitted to them. I'm not going to object because the planning board relied primarily and really singly on the comprehensive plan. But I do want Mr. Pimentel's report in the record.
Well, no, I think you're 100% correct in that regard. We do see in your, when I read your statement of support, you clearly mentioned his expert opinion, and it's also mentioned in other areas. So, and you're right in that every content should have been, so I think you would be more than happy to receive it at this point, even though normally we wouldn't, but in this case, you're in the right. So we will call this, Mr. Martin, what was my last number for A?
7, 6, I think was the last.
So this would be A7?
8,
Okay, so A7 will be introduced,
it's actually
A6, my mistake,
Yep.
okay. A6 will be introduced by the appellant. It's a document that is referenced in her, in the appeal letter. It's dated May 24th of 2022. It's prepared by Pimentel Consulting, Inc., and it's for Island Solar LLC.
May I proceed?
Yes, please.
Thank you, Mr. Chairman. So, and I just want to reference again my attachment, which is a pretty detailed analysis of our argument that I hope the board will consider. I'm going to give some brief comments highlighting our arguments tonight. First of all, I do agree with Attorney Igliosi's summary of the standards for review. Most importantly, you must find that the planning board committed prejudicial procedural error, clear error, or lack of support by the weight of the evidence in the record. We will argue that the planning board committed both clear error and that there was a lack of support by the weight of the evidence in the record. As opposed to the typical reviews that you commonly address, the concurring vote of 3 of the 5 participating members is necessary to reverse the planning board's decision. And Mr. Chairman, I notice that there are 6 of you standing, sitting there, and you had mentioned that all of you would be voting, so procedurally.
That was prior to, well, actually, only 5 of us would ever
I just
vote.
want to, again,
Correct.
just
Yeah,
to be
that's
sure.
correct.
Thank you. And finally, if you do reverse the planning board's decision, the project is remanded to the planning board in order that the board will address your decision and move forward with the project review. Now, as I open, the planning board committed clear error when denying this application. In addition, the decision is not supported by the weight of the evidence on the record, specifically regarding consistency with the comprehensive plan. We do not dispute any of the findings of fact outlined in paragraphs 1 through 6, other than a continuing discussion with the planner as to which variances are required, but that's not really before you tonight. However, the planning board clearly erred in making its finding as outlined in paragraph 7 regarding consistency with the comprehensive plan. Importantly, town planner Mark Carullo submitted a recommendation that supported approval of the application and opined that the proposal is generally consistent with the town's comprehensive plan. Additionally, land use expert and certified planner Edward Pimentel submitted a substantial report supporting approval of the project. During deliberations, Mr. Pimentel addressed the specific concerns of the board relative to the comprehensive plan. Despite the support of the land use experts and the lack of testimony challenging the land use experts, the board voted 3-2 to deny the application. Essentially, the decision provides specific and narrow references to the comprehensive plan that a couple of members focused on as support of denial. The decision states that board member Porter identified Land Use Chapter Goal 3, which states, prevent incompatible non-residential uses in residential neighborhoods, and Natural Resources Chapter Goal 2, which states, maintain the rural character in concert with concisely located development or redevelopment of existing areas. Mr. Porter stated that solar photovoltaic systems are considered a commercial land use and that the subject property is zoned residential and that the proposed facility would be literally located directly abutting the backyard and side yard of the abutting residential properties. However, as Mr. Pimentel testified, the North Smithfield zoning ordinance is clear that the town supports solar facilities in residential areas because the use is permitted by special use permit. So solar use is necessarily not an incompatible non-residential use. It is in fact compatible as determined by the town. The comprehensive plan provides the foundation of the vision of the community and provides goals and objectives, but it is the subsequent zoning ordinance and development regulations that are adopted that take into consideration these goals and objectives and then effectuate how the town exercises and achieves these goals and objectives. Same as the reference to the finding relative to the Natural Resources Chapter, Goal 1 and Action 1A2, regarding the protection of existing natural environment and mitigation of impacts of proposed developments on these environments. And the Open Space and Recreation Chapter, Goal 2 and Action 2A1, which calls for preserving land based on certain criteria. The reference was made to a heavily forested lot located within an unfragmented core forest. However, and again, this use is permitted by special use permit, as is other, frankly, more intensive uses, including residential. There are no regulations in the town's ordinance that prohibit cutting trees. The denial of this project does not prohibit cutting down trees. Instead, the planning board's job is to look at the site and mitigate any impacts to the surrounding area. In fact, in the review of the master plan application, planning board members requested that we move the solar location about 50 feet towards Lot 18 in order to further screen residential properties, which is actually going to require a variance, and we'll be before you on that. So that's the way you mitigate the impacts, not by just denying the whole project. So again, the town of North Smithfield, through legislative action, has determined that a solar facility is a use that is compatible with residential uses, so long as it meets the criteria of a special use permit, which we will be coming to you for review. That's your decision whether we meet the criteria for a special use permit. The planning board effectively vetoed this conditionally permitted use, which we can assume such a determination would be applied anywhere in this or any residential zone, particularly if it's forested. The Rhode Island Supreme Court has discussed the criteria for a special use permit, previously referred to as a conditionally permitted use. By definition, such a use is one which the local legislature has conditionally permitted and has thereby, at least implicitly, found to be harmonious with those uses which are permitted in the district. Of course, compliance with the prescribed preconditions, which are outlined in your zoning ordinance, is necessary to the establishment of a conditionally permitted use, but those conditions are addressed where it will be specifically located rather than to its desirability. So again, moving that solar facility 50 feet that the planning board would like to see is a way to locate it so that it doesn't negatively impact the surrounding area. But saying absolutely not is just not within their purview. Finally, with regard to the comments regarding the forested land, I would like to highlight the language of the statutory required finding that this is something the planning board had to find. The proposed development is consistent with the comprehensive community plan and/or has satisfactorily addressed the issues where there may be inconsistencies. Now, without agreeing that it is consistent at all, the decision states that the application does not consider or offer any mitigation to counter the disturbance. That's just not true. The project engineer, ESS, and you have that report, submitted an environmental impact statement that explained no mature trees would be cut for the project and that other by right developments, including residential, would likely require substantially more cutting than this project. Further, and stated previously, planning board members have requested, and we've agreed, to move the project 50 feet to mitigate those impacts. In summary, the town council has legislatively determined that the proposed solar use is appropriate for this zoning district. And it's within the zoning board of reviews, when you act as the zoning board, to determine whether the use meets the conditions for approval. The planning board erred in denying this application because it erroneously based its decision on a couple of sections of the comprehensive plan where the use is not necessarily, is necessarily not incompatible with residential uses. I'm sure you're aware, I'm sure that your attorneys have told you that within the last several years, the comprehensive plan used to be the main document, and the planning board particularly, could deny projects based on inconsistencies with the comprehensive plan. That's not the case anymore. A few years ago, the state legislature said when the zoning ordinance is inconsistent with the comprehensive plan, the zoning ordinance trumps. So it's really important, that's what I'd like to see you focus on, is that this use is something that the town wants. It's about, just like any by right development. Now, I'll say one other thing, and Mr. Pimentel brought this up at the planning board. If there was something in the comprehensive plan that said, this area is intended for an overlay district for a greenway space, that actually might be a way that they could have hung their hat on a denial. But your comprehensive plan doesn't say that. There's nothing in the comprehensive plan that specifically relates to this property, not the whole residential zoning district, but this property that would have allowed the planning board to deny this project. And with that, I'd welcome any questions now or after Mr. Igliozzi.
Are there any specific questions for the council regarding this matter? We can hold it open until the second presentation if we'd like. Hearing none, we'll continue both presentations, and now we'll defer to Attorney Igliozzi, who's representing the town and the planning board. Go ahead. Yes, please.
Good evening, members of the Board of Appeals. Just so the record is clear, as you know, I represent the town, and I'm appointed by the council, and Mr. Archibald normally represents the board, and he's appointed by the council. He's not appointed by me. If he was appointed by me, then there would be a conflict, and I would not be able to be here. Okay, so I want to make that clear for the record. My responsibilities here tonight really fall on, in my view, to make sure that the board focuses on the discrete issue, which is the subject matter of the appeal. So there were a couple of points. Let me just start with that procedure first. Ms. Morris Salvador mentioned the process, and I want to just first remind you, it was not a 3-2 motion to deny. It was a motion to approve the plan that failed 3-2. So that's the posture this is before you. There was a motion by the planning board to approve it. Secondly, we're going to talk briefly about the reasons why they did that, and let me just get into that right now. Ms. Morris Salvador pointed them out. I think, according to the decision, we are limited to this decision dated June 7th, 2022. I think the law is clear. We can't go beyond that for purposes of this proceeding. So there were two reasons that the motion failed, and it was recorded in the decision and signed by the chairman, Gary Pilati. And Gary Pilati was actually a motion in favor of the application, voted in favor of the application, but he signed this decision on behalf of the board after reviewing it. So one is, in fact, that they, at least based upon Mr. Porter's point of view, he suggested that this particular solar project is considered a commercial use, and therefore, because it's a commercial use, in his view, it was inconsistent. Now, Ms. Morris points out the fact that it is subject to a special use permit, and you can certainly consider that. But he went on to say something else. He was concerned with the fact that the facility would be literally located directly abutting the backyard and side yard of an abutting residential properties. So that's a factual comment that he made that was his concern. I want you to think about that, because when we get to the standard of review, it is not your job, and you are in fact statutorily prohibited from substituting your judgment for his. That was his judgment, that's adopted by the planning board. You can't substitute your understanding of the facts for his. You're bound to look at these facts, and then you have to apply the standard, and either it's a clear prejudicial error or clearly wrong. So whether or not we disagree or agree with whether or not it's inconsistent with the comprehensive plan, Mr. Porter not only pointed out the distinction between the commercial use and the residential use, which the applicant has argued against, but he also was very concerned about the proximity of the project to that abutting side yard and rear yard. And I think the planning board is entitled to be concerned with that. The second major reason, obviously the only other reason, is in fact that there was a significant 500 acres of forest there, and Mr. Porter pointed out that it's considered what they call a Rhode Island DEM unfragmented forest. I guess it means undisturbed. I don't know that. It wasn't defined at the time, but it's a term of art, I assume. And I assume if you look at the DEM regulations, I think it would apply to that. But I believe also Webster's dictionary would tell you it means undisturbed. And he suggests that the applicant did not consider or offer any mitigation action to counter the disturbance. Now, Ms. Morris Salvatore indicates that they did, but obviously they didn't do it to the satisfaction of the planning board. Otherwise, the planning board would have acknowledged that. Again, your job is not to substitute your judgment for the planning board, but to determine whether they made a clear error of law or against the weight of the evidence. So I know Ms. Morris Salvatore is focusing heavily on consistency or inconsistency with the comprehensive plan, but these are two discrete issues within that context. That's the reason it appears on the facts why they denied this, and according to Rhode Island General Laws 452330, you can only reverse it for those reasons: prejudicial error, clear error, or lack of weight. It takes three of five of you to overturn this decision, to vote to overturn it. And finally, most importantly, I mentioned it before, I mentioned it again, I'll mention it again. My job is to remind you, you cannot substitute your judgment for the planning board. So when you ask your questions, you can't be asking questions beyond this record, in my view. It's about either the evidence is here to support the applicant's appeal. If it's missing, then you can't substitute your judgment for it. That's the essence of the argument that I can make based upon this letter. Those are the standards, and I'll certainly answer any questions you want. And obviously, Ms. Morris is entitled to respond to those if she sees fit.
Before we proceed, I think it would be the benefit to most of the members if both of you, if you wish, could just define in layman's terms, none of us are practicing attorneys or even pretend to be, Can you define prejudicial procedural error? Both of you, if one says something the other doesn't agree with, then please, both of you give your opinion.
I don't mind. I just want to be clear that we are not saying that the planning board committed prejudicial procedural error. But what that would be is if some procedure that they took voted it wrong or sent out a notice that was inappropriate was prejudicial to my client. So first you'd have to do something wrong procedurally, and then it would have to be prejudicial to my client. We're not taking the position that there was prejudicial procedural error. Our argument is it was clear error because of the way they so heavily relied on the comprehensive plan, and that the weight of the evidence did not support a denial because of your own town planner supporting it and saying it's generally consistent with the comprehensive plan, and our land use expert, who spent a significant amount of time talking about consistency with the comprehensive plan. And we don't pick and choose, you know what a comprehensive plan looks like. We don't pick and, I mean, I could find inconsistencies in every project, in every comprehensive plan, but you can't pick out just one little line and say that makes the whole project inconsistent.
Thank you. I think we all understood that it wasn't that, but I think it was important for us to understand what the legal terminology exactly was. I think, unless I'm told otherwise by council, we can leave both open, and members can ask questions, and then at one point, just like with the zoning meeting, we'll close and we'll go into deliberation. Okay?
Mr. Chairman, I would just like a chance to respond to Mr. Igliosi at some point.
Well, you might as well do that now.
So, with regard to Mr. Porter's statements, which were based on the comprehensive plan, he said, and I'm paraphrasing, that it was very close to residential uses. Again, your zoning ordinance permits these solar facilities so long as they have a 100-foot buffer. That's what we proposed, 100-foot buffers. The planning board, and we haven't even gotten there yet, but the planning board in discussion said, we'd like you to move that to help out someone else, but move it towards the property owner that's giving us access. So that's one way to mitigate the impact of this solar facility. But your zoning ordinance allows, like, by right, for us to put that solar facility where we proposed it to be. Secondly, I'm going to say the same thing, and it's my notes. The planning board can allow conditions. So where Mr. Porter, basically just said, I don't like it because it's too close, they could have proposed conditions. You can make an approval subject to reasonable conditions of approval. And then finally, with regard to this 500 acres of forested land, first of all, we are clearing in this project 1% of that 500 acres. That's in the ESS report. Secondly, if Mr. Porter his finding is accurate and reasonable, that would mean that none of those 500 acres could ever be disturbed, even for, comparing by right uses to special uses by any by right use. If there was some development that was happening, he would have had to take the same position that you can't put a residential subdivision there. So I would say two things. One is, his comments were clearly based on the comprehensive plan. And number two, we could address every one, so that required finding that says, or where the inconsistencies have been addressed, we address them. So, something for your consideration.
Thank you. I guess for both councils and/or our counsel, Mr. Archambault, if he's listening in, since reference is made repeatedly in the appellant's application and also the planning board to the comp plan. Is the appellate board free to reference other sections of the comp plan as an analysis, or is that outside the lanes?
I would think that the comp plan, again, as long as it's relevant.
It's fair game.
It's fair game. I did wanted to add one, unless you disagree.
Well, I do disagree.
Okay, why is that?
Hold on, I just want to make sure it's all on the record.
Yep, that's-
I disagree because, as you said, David, the decision is what was written. So you can't now you can't support the planning board's decision with other things that they didn't make findings on.
Well,
But I
you're assuming that that's what we were going to do.
Well, no,
think the
what I
elements-
heard, Mr. Chairman, and maybe I heard wrong, was that you were going to use other sections of the comprehensive plan to consider this application.
No, my question was, in reading the comp plan relative to the references made in the actual planning board documents and your appeal, it was important to understand all aspects of the comp plan and how many of them did or did not relate to this matter. So my question is, are we free to look at and reference other aspects of the comp plan that will help us determine whether or not this was a clear error?
And I guess if you're referencing portions of the comprehensive plan that are identified in the record, then I would agree with you.
Okay, well, this one is not, so I wanted to ask that. So if it's not, and both councils feel that way, then in my argument, or my presentation, I won't reference it.
I would agree with that. It would have to be referenced either in either by the planning board or by the applicant.
Okay.
Mr. Chairman, I
Mr.
have
Marcantonio.
one question for you.
Yeah.
And you can answer it sitting down if you want, you don't have to keep walking back. When you say that special use permit is by right, the way I interpret, for the many years I've been here, it's not by right. That's why you need a special use permit. It's not a Y. Only a Y gives you a special use permit. But you
that's
were
true.
saying the S gives you by right.
No, and I apologize if I misspoke,
what-
but the S is a special use permit, which is a conditionally permitted use.
Right.
So the town council has decided that that use is acceptable and generally harmonious in that residential zoning district
With a lot of conditions.
with conditions. And I always tell my municipal clients, it's like a checkbox. If you can check the box, whatever that box may be, for example, a drive-through use, sometimes you have to have 10 queuing spaces for cars. If you check that box, I know there's other standards, but you're that much further to get your special use permit. It's conditionally permitted, and that's important because it is meant to be in that zoning district, and then you look at the specific piece of property. And by the way, let's be clear, the planning board doesn't make that decision. You do. So when they're looking at the master plan and the comprehensive plan consistency, that's a different analysis than when you're looking at it.
Yeah, I realize that. But
So I did not mean to say it's a by right use. It is a conditionally permitted use. So it's intended to be permitted if we meet all the conditions.
usually it's permitted if the planning board, in their eyes and ears, feel as though it's worthy of that particular area before they send it to us. And then we give it a special use permit.
Well, but that's, I think we're going a little bit off
I'm
topic.
just going on a special use permit.
But a special use permit, just like a variance, any relief that this board, sitting as a board of review, grants, a special use permit is an allowed use subject to the terms and conditions that we know. So therefore, is an allowed use in all districts subject to the conditions of a special use permit. So you can't categorically state by any stretch, in my opinion, that it is not an allowable use. It's a conditional allowable use. But, you know, if you read Mr. Porter's quote, and again, we want to stay in the center lane here, and again, I'll just read before we continue, just to reiterate what both councils have noted, quote, "The Board of Appeals shall not reverse a decision of the planning board or administrative officer except on a finding of prejudicial procedural error, clear error, or lack of support of the weight of the evidence in the record." The appellant has clearly stated for the record that they believe that the issue at hand is the, quote, "clear error" committed by the planning board. So since that is what is in the appeal, we should focus on whether or not a clear error was committed by the planning board. I think we can roll into, are you also?
Well, I want to be clear, again, it's not just clear error, it's that it was not supported by the weight of the evidence on the record. And the reason why that's important is because you had two land use experts, your town planner and our land use expert, that testified that this was consistent with the comprehensive plan. And then one of the members took specific small items out of your comprehensive plan and made that inconsistent, and that is not appropriate.
No, we understand. So you're also indicating that, you're also emphasizing, quote, "or lack of support by the weight of the evidence in the record." Okay. I think we can evolve or roll into deliberation unless we have specific follow-up questions for either council. Do we have specific questions for them?
No, I think Ms. Morris clarified, if you're gonna close and start deliberations, I just want to, again, now just tie up the posture, right? The board, I know you're familiar with the interaction between the zoning board and the planning board, but at this moment in time, this application was what they call the first step. Just if you're all familiar, master plan.
Master plan.
This is the concept plan only. If this board were to take a negative action and reverse this back, it goes back to the planning board, and then comes back to you for the special use permit, then goes back to the planning board, and then back to the planning board again. So this is like very, very premature in the process. I just wanted to put that on the record because I think the chairman's right. Focus on whether or not you believe this was a clear error and/or it not supported by the weight of evidence. I'm satisfied that that's the focus of your analysis when you deliberate, and the town will be satisfied with that deliberation.
And as counsel, just to reinforce what counsel said, both, but our counsel for the town more specifically, we know some of us have experience with planning board, some don't, but master plan is entry level. So and we know that when we get a positive recommendation in a normal procedural from the planning board, it is only them telling us that they approve the master plan, then a zoning action is required. If the zoning action is denied, then the plan goes away. If the zoning action is granted, it goes back to the planning board to go through all of the other, excuse my term, minutia to get you to the point of approval. So the inherent point in that is that there are multiple levels at which ambiguities or issues can be resolved in a normal process. So I don't think we need to, because I'm assuming we need to deliberate without input from either party. So I assume at this point.
That would be my suggestion.
Yeah, I mean, if the board has questions, I've always allowed people to ask more questions.
Well, if we have as we're deliberating, if we have a specific issue, we'll defer to our counsel, who's with us virtually, and if our counsel, we'll rely on him for his direction. But I think it's reasonable to entertain a motion to close the present. Oh, excuse me, I'm sorry, my mistake. We do have members of the public present, and my interpretation when I read what a appellate meeting, zoning board of appeal meeting is supposed to mean is that it's open to all to all. So I'm assuming the public is allowed to comment. Is that?
Mr. Chairman, I'll just make two.
Hold on, Steve, go ahead.
Yeah, no, I will not allow public comment at your hearing. I think you should take the evidence based upon the way it's been presented by the appellant and by the town attorney, Mr. Igliosi, and I think you should weigh it and find whether you think there's a clear error or some error based on the lack of weight of evidence that's on the record. I don't think this is open to the public in terms of having the public give opinions or testimony. That's not the purpose of a Board of Appeals, and I would not allow public testimony.
Okay, thank you.
Well,
Hold on one moment.
I actually disagree. Even I want to protect the record. I agree with the neighbor. The caveat, though, is that anybody that speaks has to confine their comments to the record. So I do not object to anyone speaking, but they cannot provide you with testimony that's not in the record.
Well, after, my obligation is to abide by the direction and advice given by counsel. All due respect to the members of the public in attendance, I stepped back only because that was my interpretation of what I read, but that's why we have counsel to give us direction. Be mindful of the fact that this proceeding, as you've heard both counselors explain, is an appeal. If this board approves or accepts the appeal, then we remand it back to the planning board and the process continues. And all issues relative to fencing and everything else under the sun, drainage and landscaping, that is then open for the public to participate and make its contribution. If this board denies the appeal, then the issue is moot. There is nothing to discuss, and they're free to go to the Superior Court and further litigate. So in that regard, for this specific type of appeal, I'll defer to our legal counsel, and we will not entertain public comment. I apologize if you feel insulted in that regard, but I think that's what we're going to do. Do we have a motion to close the presentation part of this meeting?
Mr. Chairman, I do have a comment on that.
Go ahead.
As far as what was posted, it says that participation must be in person. It doesn't say participation by just the the Board of Appeals. It actually says if you want to participate, you have to be in person. So whether or not they were mailed something, this was posted everywhere. So I don't think that it's fair that you have something posted, people are coming here to say something, and now we can't let them? Why?
Yeah, but you're interpreting that sentence in one direction, and the other direction could mean that it applies to the council that are representing, so.
I mean, I'm arguing for the neighbor. I can read it to you.
This is about focusing on whether there was a clear error or whether there was a lack of support of the weight of the evidence on the record. This is the danger you get into when you allow public testimony. There's nothing in state law that says that there has to be public testimony tonight. I'm going to advise you again to restrict this hearing as a Board of Appeal to the evidence that's been presented by the appellant, by the town, and not to allow public testimony. Thank you.
David, it's right here.
Mr. Chairman, I guess my only comment would be, I think there's a distinction here to be made.
Yes.
I don't think that the board can allow any testimony about any facts to persuade you to the outcome of this hearing. So for purposes, especially since we only have two people that want to speak, Mr. Archibald doesn't know that, but I do. I would not have an objection as long as Ms. Morris doesn't object and the board is careful to guide and instruct them that they can't testify about fences or trees or square footage or anything else. They have to say something about exactly what's here before you tonight.
But I still think that as it relates to this specific appeal, we're reviewing an appeal of a planning board decision, and we're being, the law is very clear that we need to stay specifically with the information that was provided in the appellant's documentation and the planning board submission. So therefore, it seems clear that if we then defer to opinions or facts presented by members of the public outside that domain, we are violating the very rules that you told us we could not.
Mr. Chairman, if I, because it's right in the statute. Listen, I'm actually helping the opposition here right now. So I want to preserve the record. If this gets appealed, I don't want them to say we didn't give them a chance to talk. So under 452369, appeals, public hearing, at the hearing, any party may appear in person or be represented by an agent or attorney.
I agree, that's what I read as well. That's why I asked the question.
So by the way, they can't say much, but I'd like you to give them the opportunity to speak because that preserves my record. If this gets appealed and he says I never got a chance to talk, we're right back here.
What is before we decide, can you just explain what's the nature, I'm sorry, Steve?
The argument that someone can appear, and then we're going to infer from there that they have the right to speak are two different things. Two different arguments going on there, and I'm not going to get into a debate here publicly. I'm going to give you my opinion, and then you're going to make a decision based upon it. The state law says that anyone can show up at the hearing. People are supposed to get notice. That complies with due process. You've given that. You've listened to the argument of the appellant, and you've listened to the attorney's argument for the town. Now, the attorney for the town has graciously said he'd consent to a couple of people speaking in the audience if you could restrict it just to the record. It's a slippery slope. I'm going to give you legal advice, and then you ultimately have to decide what to do. I've given you my opinion that this is not open to the public for the public to speak, for the very reasons that I've set forth, and I don't care to debate it anymore. I've given you my opinion. You've heard the appellant's argument, and you've heard the town's argument. I think at this point you should make a decision whether or not you care to allow a couple of people from the audience to speak, and if you do, they'd have to be restricted very carefully to only what was in the record.
Okay, thank you. Let's get this wrapped up. Sir, if you could stand, please. What's your name? And briefly, if you could go to the podium, I just want you, you're not going to testify yet or speak, I just want you to explain what is it, who are you, how do you relate to this case, so then we can decide.
Right. My name is Donald Croto. I'm an abutter to that piece of property. By 800 feet of borders 800 feet of my property on the right side, and that's my huge concerns. I've had 3 other solar companies approach us, my wife and I, about selling or leasing property.
Okay, all right, I think honestly though, all due respect, your presentation is with regard to whether you approve or disapprove of the application, because it applies to you directly. That opinion should really be restricted to the planning board, and if this appeal is granted, and it then comes to this board sitting as the zoning board of review, then you're welcome back to read us a book of everything you want to say, because that would be relevant to us as the zoning board of review. But I have to defer to legal counsel. All due respect, sir, we gave you a moment to express what your thoughts were, but I don't think we can entertain your testimony, because if we do, you may be prejudicing the record in the other way, which would hurt you. So I think, all due respect, sir, we have to go with what we've got, and if this does move forward, you'll have more than many opportunities to comment in the favor or the opposition. So
even if it's a zoning board issue?
Yes, if it comes before the zoning board, it's open, you're in a butter, you will be notified if this or anything else that affects you. If anything ever comes that's within your 200-foot boundary, you will always be invited and you can speak freely. In this regard, I think you're going to end up prejudicing yourself, and it's going to skew things for the board, which we don't want to do. So I would ask you to step aside, and we'll proceed. I do appreciate your consideration. So with that being said, I think we'll take a motion to close. comment, knowing that if we have a specific legal matter that we need clarified from counsel, we can always defer to our counsel, because that's why he's there. But do I have a motion?
I'll make a motion.
Mr. Martin makes a motion to,
To close the testimony of the appellate and the town.
okay, second?
I'll second.
Okay, second. So now we'll go into, and the deliberation is really not, we don't have our criteria, so it's going to be a fairly straightforward. I prepared some notes and comments based on my review. Members are free to come in, and we can do whatever we want. Normally, as the Zoning Board of Review, we make a motion in favor. We don't have to do that, but that's what we always do. So we can make a motion in favor, and then you either vote to approve, or which would be to accept the appeal, which would remand the decision back to the planning board, or you vote against it, which would deny the appeal. All right, so that would be the procedural manner, and we'll do a roll call vote. So if we stick just to the findings, you know, this, of course, is a little bit ambiguous, but it's also very clear in some regards. Mr. Porter's comment, which appears to be, there's a little bit of a contradiction here within the planning board itself. The planner, in the planner's report, planning office findings, which all of us have, they state clearly that, quote, generally consistent with the comp plan. The planner, in fact, during this review, makes reference to the ground-mounted solar ordinance on multiple occasions. So it's clear that the planner reviewing the solar ordinance does not take issue with it being an acceptable use subject to the SUP. In fact, the planner breaks out that the SUP is required, highlights whatever relief they may or may not need from 5.7 with regard to setbacks where they would need variances. So the planner is of the opinion that there is nothing wrong with this proposed use if it is granted the SUP. Mr. Porter then states, quote, photovoltaic systems are considered a commercial land use and the subject property is zoned residential. The proposed facility would be literally located directly abutting the back and side yard of abutting residential properties. I mean, without being judgmental in any way, shape, or form, we have an ordinance, 5.7, that, truth be told, Mr. Zwolinski is here. I was on the ordinance committee that wrote the ordinance. So that ordinance clearly was intended for solar voltaic systems to be put anywhere in this town subject to the issuance of a special use permit. So while we're not, I'm certainly not, and I don't think the board should argue with Mr. Porter's statement as to whether we or anyone else consider it a commercial land use, that's really not the issue. The issue is that it is an allowable use in a residential district if a special use permit is granted by by the Zoning Board of Review. Item 3 within that planning office findings, it's also, quote, no significant negative environmental impacts, which appears to contradict or at least run afoul of the other quote that's provided, whereby Mr. Porter states, heavily forested lot, which is located within the RIDEM designated unfragmented forest. Proposed solar would clear approximately 13 acres. So the planner didn't find anything significant for negative environmental impact. Solar voltaic systems that we already went over there. The other thing that, again, we are to weigh what we know and what we see. A reference is made to a concern, which is clearly stated because it was included in the decision, that would clear-cut approximately 13 acres of the RIDEM unfragmented forest. We know both from what the appellant had submitted, I think there was a ratio given that it was a very small percentage of the total lot. But we also know, was it 1%? We also know that this town has no deforesting, clear-cutting ordinance. So as the appellant attorney referenced, we all know, because we deal with this when we're sitting here as review members, any one of us with property can cut as many trees down as we want. Well, if you run afoul of the DEM, that's a different issue. That's your own problem with the DEM, but the town has no ordinance, and that's our only authority. The town has no ordinance that says whether it's a good or bad thing to do. We can't judge what's good or bad. We can only judge what is, you know? So that's another thing that runs afoul.
To interrupt you, but the zoning official just notified me that you took a motion in second, but there was no vote.
Oh, on to close the hearing? Oh, my mistake. Turn the clock back. All in favor of that motion?
Aye.
Aye. Opposed? I apologize. Good call. That's because I'm sitting as an appellant here as opposed to review, so my mind is. Further on, within that same quote, Mr. Porter notes the, quote, "The application does not consider or offer any mitigation action to counter the disturbance." My concern when I was thinking this through was that is in fact a planning board responsibility. If they didn't offer, then the planning board should have made them offer, and if they refused to offer, then they could state that, but they don't state that they refused, and appellant's counsel has indicated that they did offer. So we don't want to get into the who and the what, but this quote does not say that they offered or that they refused to offer. It just said, does not consider or offer any. So in my opinion, that really is something that the planning board should be engaging them about, because that's part of their review process. That's why they're there. I mean, the comp plan, even though I was told we have to stay within the boundaries, I think it's clear that the comp plan can be interpreted in multiple directions. You can find areas within the comp plan where the rural preservation of our neighborhoods and rural settings is tantamount. Then we can find sections where alternate energy is encouraged and commercial tax base is encouraged. So by no means is the comp plan a clear path in any direction. It can take you in the direction that you may want to follow it, and it tries to be fair to everyone who has a vested interest in their town. So I think when it's all said and done, in my opinion, with all of what we see, knowing that I'm leaning towards the clearly, my opinion at this point from what I can see is that it is clear error, and or it's also lack of support of the weight of the evidence in the record. If the record includes the fact that we have 5.7, which is referenced in the information, the record is clear in that we know that there is no cutting ordinance. So, I mean, I think that there is just not enough evidence here to fairly dismiss this and reject it at master plan level. I think there are many opportunities for the planning board to solve issues that they have. And I think it would be unfair, because if we were to abide by the reality that solar 5.7 could not be used in residential districts, then we have them all over the place. We've approved too many to count, and that's why we have the ordinance. So that's where I'm leaning. Members?
Mr. Chairman, I'd just like to add for the lack of support for weight of evidence. You know, you mentioned the land use expert being the planner. We also have a report from the ESS group, who are experts in land use, that basically address all the issues that Mr. Porter was mentioning in his document. So.
And it was not, I believe that report was also referenced by the planner in its findings, and I don't think they took any issue with that ESS report.
Yep.
in addition to the gentleman who's referenced further on that the attorney for the appellant gave us his report. That was also referenced in the planner, so.
Yep.
Do we have additional comments?
Okay. I feel as though the planning department did the best they could, but I feel as though, you know, maybe if they looked at it again, they may have a different opinion, but that ain't what we're supposed to be looking at. We're supposed to be looking at, did they do the right thing based on facts that they told us about? And that's the thing that's a little confusing. You know, what would happen? Is there a way of sending it back to the planning board without denying it or approving it?
Well, what we're clearly defined is we remand it back to them so that it would move forward at the point in which it was interrupted. So the bottom line is yes. If we remand it back to them, we're basically saying to them, you missed on this one, try it again. And then if they continued and they still denied, and they had just cause to deny, then the applicant either accepts that or they appeal again. So I don't know, but that is why that term remand is there. We can't make conditions, we can only send it back and advise them of what we noted and the reason for our decision, and then they react accordingly. Ultimately, it still becomes their decision. I think the intent of the law is we want to try to get it right, and since we're not members of the planning board, we don't know how to make it right because that's not our job.
Mr. Chairman, if I may, I think you explained that very well, Vinnie, and I think the caveat of caution here is you don't want to substitute your own judgment. You have to be very careful, and I think you explained that well. Vinnie, do you understand at this point? You have more questions on how you're supposed to deliberate and think?
Okay, he's good, Steve.
Thank you.
Any further, Mike, Paul? Nothing? Okay, well, with that being said, I think we should take a moment. Who can prepare the text? Gail, you want to prepare the text, or Scott? Well, we want to make a motion, if you want to write it down, that you can put it on your phone, whatever is easier. We want to make a motion, it can come from the floor. I mean, it's a motion, again, don't read into this, we always make it in the affirmative. So the motion would be to grant, that's the proper terminology, grant the appeal of the applicant to to grant the appeal of the decision of the planning board master plan rejection, which was dated, I guess we should get it right and get the notes in there correctly. When's that? Where's that planning board letter that references? Yeah, here we go. Decision letter. So the motion would be to grant the appeal of the applicant to remand back the decision, the negative decision, or let's see exactly what they referred to it as. Yep, go ahead.
If I may, you're on the right track. Make the motion that the board intends to do this, that the board will grant the belief that the appellant seeks to overturn the decision of the planning board, and then to remand the decision back to the planning board for further hearing.
Okay.
That the matter was before the board before it was appealed.
Okay. Did you get that, Gail? And the decision was dated decision letter is June 7th, yeah, of 2022, and it's for Island Solar LLC. Well, it was received on June 30th, but yeah, it was recorded on June 30th, the decision, and of course, we know it's Island Solar LLC. So if you've finished, you can read it back when you're ready.
Okay. Motion to grant the relief of the applicant of Islander Solar LLC, Joseph and Sandra Authier, to appeal the decision of the Town of North Smithfield Planning Board regarding the denial of the master plan for the property located at 0 and 850 Iron Mine Hill Road, being Plat 16, Lot 18 and 19, zoning district RA, to remand back to the planning board for further hearing.
I think you should note, it's not relief, we're granting the appeal.
Appeal. Okay.
You're granting the appeal, you're overturning the decision
Okay,
and remanding it back
okay.
for further proceedings.
So we need to add in overturning the decision, remanding it back for further deliberation?
No,
Or-
for further proceedings.
For
They
further
hear-
proceedings,
For further
okay.
proceeding.
Which, for the sake of the record, which I think would be, they would now be making a recommendation to you on your special use permit,
Yep,
because they didn't do that in their
Correct.
decision.
correct.
So that's the next step.
Yep. You want to reread that?
Okay. So a motion to grant the relief of application Islander Solar,
No,
Oh.
grant the.
Oh, I'm sorry.
Appeal,
granting the repeal,
appeal,
appeal.
yeah. Grant the appeal and overturn the decision of the North Smithfield Planning Board master plan denial from their decision dated June 7th, 2022.
Okay. So a motion to grant the appeal and overturn the North Smithfield Planning Board for Islander Solar LLC, Joseph and Sandra Authier, to, did I say that? Grant and overturn? Yeah, to remand back to the planning board for further proceedings. Did I get
Yeah, I
that
think
right?
I missed you something. Read that again slowly.
Okay, I'm gonna try this one. Motion to grant the appeal and overturn the North Smithfield Planning Board.
The decision of, overturn the decision of
Sure.
the North Smithfield Planning Board master plan.
Okay, so I'll put the Islander Solar just before that,
Yeah.
okay? Motion to grant the appeal and overturn the decision for Islander Solar LLC, Joseph and Sandra Authier, the decision of the Town of North Smithfield Planning Board regarding their denial of the master plan for the property located at 0 and 850 Iron Mine Hill Road, being Plat 16, Lot 18 and 19, zoning district RA, and to remand back to the planning board for further proceedings.
That's good. Does that meet everyone's legal muster?
It does, Mr. Chairman. I'll make sure that the planning board understands that
Okay.
when it gets there.
Okay, counsel, you're okay? Yes. Okay.
I'll second it.
We have a second by Mr. Martin.
So we have to all vote on it?
Yeah, we'll have one moment, please. Yeah, we'll have a roll call vote, Tiffany, please. All five will vote. It's 3 to approve.
Mr. Najarian,
Aye, yes.
Mr. Martin,
Yes.
Mr. Pasquarello,
Yes.
Mr. Marcantonio,
Yes.
Mrs. Burlingame.
Yes.
Okay, the motion, the appeal passes. Best of luck to all parties, and again, for the public, I hope you understand why we had to do what we did. We'll stand in adjournment. Can we have a motion to
I'll
adjourn?
make a motion to adjourn.
Second?
Second?
All those in favor?
Aye.
Aye, we're adjourned. Thank you.
Thank you very much, Mr. Chairman.
Have a good.